Thank you for being here after lunch. Woo! Energy. Hello, my name is Deborah Guerrero. I'm with the NRP Group, and I've been with them now for about 13 years. And we are a developer partnering primarily with nonprofits and public entities. And we do not only development, but construction and then property management, and primarily tax credit developments, as well as urban core and market rate developments. So that's my background. We're very excited that all of you are here, a lot of new faces, and we welcome you to Texas, to TAP, and to our session today. And so, just to kind of give you a brief idea of the format, the name of this panel today is Fair Housing Choices, and we will be talking primarily about the Affirmative Furthering Fair Housing Rule, also about the recent, well, not recent anymore, it's now a year old, Supreme Court decision regarding disparate impact, and just in general, what has occurred in the last year because of or in spite of these particular policies and opinions, and just what's going on in terms nationally, how it has impacted us not only nationally but also locally, and more importantly, how is it impacting being able to put affordable housing units on the ground. We have a great panel of speakers, and I'll go into a brief bio about each of them, and so we'll give each of them about 5 to 7 minutes to give a brief presentation and visit with you on the topics, and then we'll do question and answers. And I ask that if you want to ask a question, if you could go to the mic, that would be great, because we are filming this particular panel, and we want to make sure that when you replay this to listen to your question or whatever the answer was, that you can hear the question that was asked. So I'm going to begin by introducing our panel, just to kind of give you a brief idea of who everybody is. And I'm going to begin with Scott Marks. And of course, I'm missing his bio here, so thank goodness I know him. But Scott, as many of you know, has been involved in the housing tax credit industry, not only as an attorney, and he is now with Coates Rose, or he has been with Coates Rose for a very long time, but also on the development side. So he has been involved in putting applications together and closing deals and doing 8609s and everything that goes with that particular closing a deal, which is important. But Scott has also been he's been watching what's going on, especially when it's come to Texas and how we have been impacted by, and how the nation has been impacted by the ICP case, the TDHCA, or ICP versus TDHCA, and just in general what's going on with fair housing. So I'm really glad that Scott is here. He is also recently elected to the TAP board of directors, and we're very proud of Scott and what he has contributed to TAP over the years and continues to contribute. We also have Suzanne Hemphill. She is with the Texas Department of Housing and Community Affairs. She is the Fair Housing Project Manager. She has been with the department for 6 years. She's really been involved in a lot of analysis of data. She knows how to map, I guess. That's what your bio says. And very familiar with the guidelines and regulations that TDHCA has to follow, that are, again, the regulations that come nationally and how they impact the agency and affordable housing. She earned her Bachelor's of Business Administration and Economics from the University of Iowa, and she has a Master's of Urban Planning from the University of Illinois. And she actually manages the agency's efforts to comply with the Fair Housing Act and the Affirmative Furthering Fair Housing Rule here in Texas. And she is here primarily only to talk about what that plan is. And it's really important because we know that it's out there, but we're not sure what the state of Texas is going to do to really plan and make sure that we meet the requirements of the federal government, or HUD's requirements. We also have Mark Shelburne, who is right here. Novogradac. I have actually participated with Mark around in other parts of outside the state of Texas because he's the expert. He truly is an expert on fair housing, allocation policies, program compliance, policy innovation, and other state agencies and local governments actually go to him for help in trying to establish and craft their own ways of complying with regulations. And so he is one of the top experts. I'm really glad he's here in Texas. And he has previously worked as general counsel what general counsel of a LIHTC equity investor. I'm not sure which one, but I'm sure he'll be able to tell us. And he also is an expert on qualified allocation plans around the country. And he is a graduate of, we were just talking about this, he got his law degree, planning and public policy degrees from the University at North Carolina at Chapel Hill. So we're really glad that Mark is here to visit with us. And then lastly, we have Gary Sweeney, who is the Regional Director of the Office of Fair Housing and Equal Opportunity, Region 6 for HUD. I was especially excited to meet him because my colleague here, Jay Johnson, said that he has a lot to share, and especially when it comes to affirmative furthering fair housing and the rules. He has been around since about 1978, which when I was doing my research on just kind of the history of the affirmative fair housing, knowing that people have been talking about this forever, since the 1960s. So it'll be really interesting to hear his perspective and honestly how this rule is different than what has been proposed in the past, and more importantly, how it's been implemented in the past. So Gary Sweeney is here to talk about that. Again, he is the Regional Director of Fair Housing and is responsible for activities not only in Texas, but New Mexico, Oklahoma, Arkansas, and Louisiana. So he's got a lot of states. So we're going to begin with Mark, who will give us sort of a brief overview of both, fair housing and some of the policies that are out there that we just discussed. Then we'll turn it over to Scott to talk about some of the legal cases, legal ramifications, what's going on. And then we'll turn it over to Gary, who will talk specifically about affirmative furthering fair housing and how the rule and how states and local governments, the guidance that they've been given to how best to implement. And then Suzanne will specifically talk about Texas. So I'm going to go ahead and turn it over to Mark, and we'll get this conversation started. And honestly, if you have a question, stand up and let's ask it. Let's have a real good conversation, because it's important that we all know exactly how these rules impact what we do. So, Mark?
Thank you for that far too kind introduction. Yes, Mark Shelburne. I'm a consultant with Novogradac and Company. Not an accountant. Don't ask me about math. But previously was in-house counsel for the North Carolina Housing Finance Agency. And that's where I got interested in this issue. And I'd like to, at the outset, recognize, I was trying to think about which analogy I should use. It's like coming to Kentucky and talking about horse racing, or coming to California to talk about earthquakes. I'm not sure which is more appropriate, but I get that y'all here in Texas, well, first of all, you also say y'all, which is nice for some of my national presentations. People don't. Y'all get a lot about fair housing. There's a lot of experts here in the room. So with that said, I'm going to cover some of the basics, because even for folks that have some familiarity with it, there's distinctions that aren't always obvious and clear. But I apologize if you are indeed an expert. You're welcome to tune out for at least part of what I'm talking about. It's a good time to check your phone, that kind of thing. So one thing I always like to emphasize when giving this presentation, well, what I often emphasize is, even though I'm an attorney and talking about things that sound like advice, I'm not giving you legal advice. So I have to say that. So now I'll proceed to talk about things that are legal that sound like advice. What I always like to emphasize is that there's really two different areas. That there's what is required legally and what are policy considerations. So there is a lot of overlap, however you define it, but they really are not the same. Those are two different things that you've always got to try to keep in mind. Are we talking about what's required under the law, or are we talking about what may or may not be good or bad policy. So again, those are just things, whenever you're talking about these issues, and it's really true in a lot of contexts, but it's especially true here, you've got to keep in mind that those are two distinct things that you always got to think about, again, that do have a lot of overlap. So the other thing I always like to remind people when talking about fair housing is that there are 7 protected classes. Now, we tend to focus on just the one for the most part, which is understandable given our nation's history, but there are 7. All 7 are equally consequential under the law. And the other thing to know about this is that this is it. This is only these 7. So questions of veterans, poverty, those kinds of things, they're not on there. They are not legally protected classes under fair housing. So that's, again, something you got to keep in mind is it's all of these and no more of these. And so again, something you got to keep in mind. Stating the obvious, but it's one of those things that's easy to forget when you're trying to think about what matters under fair housing. So I've got this matrix, and I mentioned before we started that some of y'all in the back, not the matrix yet, some of y'all at the back may have trouble reading this, and so, presuming it's worth reading, which is, I'm not saying it is, you might want to come up a little further. And you're going to hear some of this from some of the other presenters too, but I think, again, for some of these concepts, it's important to hear it more than once or more than one way to try to help it sink in. So as I divide up fair housing, have it into 3 different broad categories, and someone else could do it a different way, but this is how I think about it. The most obvious, of course, is intentional discrimination, which is what people, generally speaking, think of with fair housing, but that's not what we're going to talk about really today. Then there's disparate impact, which again, y'all know a lot about here in Texas. It's still, though, less common than happens with the intentional discrimination, at least in terms of what gets to the courts. And there's some complicated proof issues. And then the third is affirmatively furthering fair housing, which, as it currently stands, is applicable when you accept HUD funding. So next we get into the very large matrix here, which I believe these materials will be available later through TAP, and so you wouldn't necessarily have to write this down, again, presuming that it would be worth writing down. But what you've got here in this first column is really those first 2 categories, the notion of intentional discrimination and disparate impact, because those 2 really are very different than affirmatively furthering. And so they apply nationwide. I mean, there's obviously, as with any law, there's a few exceptions, but for the most part, those apply to any kind of housing in any circumstance. And the other thing to think about is to think about how these different rules, these different laws apply at the project level and how they apply at the program level. Because the laws apply to both, but they apply differently. Now, we're going to talk today pretty much exclusively about the program level, but they also apply naturally at the project level. And that's really where it happens most often, because there's a lot more projects than programs. And so at the project level, so for owners and managers, it means you can't intentionally discriminate or have policies or practices which have a disparate impact. And the example, and I actually had this up here before the HUD guidance came out, the example for that would be screening criteria for people with disabilities, is one way to do it, or just screening criteria in general, like for criminal history. So that's something that could have a disparate impact and be applicable at the property level. So at the program level, it's the same thing. And as you see, this is the presentation that I've done. In fact, some of you guys have probably had the misfortune of having to hear me twice, because I've given the same presentation, well, 1 or 2 times, we'll say, well, more than that, around the country. And this is the example I use, is y'all's case, because that was the Supreme Court case, was on disparate impact. That's what the court held, is that it exists. And so how is it enforced? It's through HUD administrative complaints or in the federal court. So that is the concept of disparate impact and intentional discrimination. And in those instances, basically what's happening is someone is saying, you've done something wrong, or I'm accusing you of doing something wrong. You've violated the law, you have committed some bad act. With the notion of disparate impact, you may not have intended to, but nevertheless, you have violated law, and then the HUD or the court decides that. Well, the most important thing to remember with the distinction is with affirmatively furthering is it's more than that. With affirmatively furthering, what's happening is the government that's receiving the money is saying, we're going to use this not only to build and rehabilitate affordable housing, but we're going to use this federal money to desegregate our jurisdiction. And it is those two purposes from a federal perspective are indistinguishably important. From the federal perspective, if you just look at the, what Congress enacted, back 40 something years ago, that's what they said, is that you have to use this federal money to desegregate America, to affirmatively further fair housing. That's the point of it. So it's no different than any other kind of money you get from the feds where it's got more than one purpose. That's one of the purposes. Always has been one of the purposes. And so it's just now that we've got this new rule that came into effect about a year ago that's saying how it's going to work. But the rule is new, the requirement isn't. And so it kicks in when you're accepting these federal subsidies. The question of how it relates to the housing credit program is a little bit different. But in states like Texas, where the same agency has both, it really isn't that different. It still applies. And so at the property level, basically the notion is you've got to use your property to desegregate America. So you have to do the affirmatively furthering fair housing marketing plans. So your outreach to people that are the least likely to apply to live where you're going to live, so as to have your property contribute to desegregation. And so at the program level, though, is where it starts to get complicated. So it's jurisdictions using this HUD funding must use all their program funds to advance desegregation. And so the example I've got up here would be a set aside for people with disabilities, but there's lots of other examples. And it's enforced the same way. HUD administrative complaints, the federal courts, plus HUD is going to review the plans that folks come up with. So that's the legal side. What is the policy side? Well, this is my favorite quote in talking about this. Explanations exist. They have existed for all time. There's always a well-known solution to every human problem. Neat, plausible, and wrong. H.L. Mencken. So that's something you got to keep in mind whenever you're in this policy context. And so if you have come here for answers, at least from me, this will be one of the ways in which you're disappointed in my presentation, because you are not going to get answers. Instead, what you're going to get are questions. And I've got some justifications for why I'm putting the questions up here. He who asks the question is a fool for 5 minutes. Who does not ask one remains a fool forever. It's not that they can't see the solution, they can't see the problem. There are no right answers to wrong questions, and judge a man by his questions rather than his answers. So you're welcome to do that, because I'm about to ask a bunch of questions. So what do you have to do here when you're thinking about policy making? Well, what are your objectives? Is it legal compliance, which makes sense? Is it helping households, particular households, or is it to change society, to change the way we're made up as a country, or as a state in this case? And then, so those are the questions. Which of those? All, some? And then even among those, the next questions are, well, how do you define the terms and those desired outcomes? Is it integration? Is it to enhance the access to areas of opportunity? Is it revitalization? Is it to improve people's quality of life? And then there's the question of, well, okay, even if you've got those defined, what resources are available? Which ones are you going to use? So within the context of legal compliance, there's what we just talked about, disparate impact, correcting a past or ongoing wrong. Then there's affirmatively furthering, advancing integration with HUD funds. And then here, there's the ICP case, the court order, the settlement agreement that's still going on right now. So then there's the question of helping households. Well, one way to do that, as some people will say, is moving to opportunity. So you add affordable housing in certain areas. But then there's the other way to help households is right where they live. So you fix the housing, you add amenities to their current neighborhoods. So then there's the question, so let's not think about helping individual households. How are we going to change our community? Well, is it to increase integration? So got some jargon up here, dissimilarity index. So that's where you measure the extent to which a particular geographic area is integrated. And so the lower the number, the more integrated it is. And so based on the two categories being compared. So that's one question. Or is it that you're going to try to improve neighborhoods? You have fewer blighted structures, more activities. So integration, well, okay, to what degree? What is integration? When is that achieved? What level do you want to do it? And which protected classes are you talking about here? And then is it going to be at the property level and or the neighborhood level? So areas of opportunity, how do they get defined? I know a lot of this is very advanced here in Texas, but some of you work elsewhere, but you can always rethink it. What is the particular income level or poverty rate? Type and quality of amenities and services, the proximity to possible employers, the quality of schools, access to transit. There's no one formal answer to any of these questions. A lot of states have come up with their own answers, and that is what applies there, but that's their interpretation. So, what is community revitalization? Well, what geographic scope are you covering? Is it a particular block, a neighborhood, an area of a city, an entire county? Are you trying to change the housing conditions, add more shopping and services? Do you want better public services, better parks, that kind of thing? Or do you want reduced crime rate? So quality of life. This is where it really starts getting complicated, is this last concept of what is someone having an improved quality of life. So move to an area of opportunity, you have a better apartment, better amenities, your school may be better, you got a easier commute to your job, maybe you have a better job, but do you feel comfortable in that new neighborhood? Do you know any of your neighbors? Is it anywhere near your church, your cousins, that kind of thing? So your community, is that really where you want to be? So instead, rehabilitate the housing. Add services, add amenities to where so you don't leave your community, but you make your community better. Well, that's great until maybe you can't afford your rent anymore or your property taxes, and you get gentrified out. And so again, this is why anyone who says, "Oh yeah, this is exactly what you got to do. This is the answer," you need to give them another look and back it up a little bit, because it's complicated. And because I started studying this issue back in 2003, because I was early on in my time in North Carolina, and the state of New Jersey got sued, and it shut down their allocation round. It stopped, and it occurred to me as new in-house counsel, that was pretty bad. Don't want to have your allocation round shut down. So I started paying attention, and the more I learned, the more I realized that that's what there are, more and more questions. And ultimately, yes, you got to start answering these things, but you got to be careful and deliberate and thoughtful about it, because the more you learn, the more you realize there's a different perspective that you hadn't thought about that is completely different than what you may have thought made sense. So last of all, what are the resources available? Obviously the housing credit, appropriated capital sources, different operating subsidies, and various combinations of the above. And then how do you distribute them? Do you pick certain objectives and do those first? Do you balance them? And if so, to what extent? And that is the topic that is to a certain extent being discussed in the panel that you're not in right now for QAPs. So by the way, thank you for being here instead. So with that, I'll probably take more than my fair share of
Well,
time.
Mark, I just want to ask you one question, though.
Yes.
So those are all the questions. Is the answer the same in every state?
Oh, no.
And
it
what
shouldn't
determines
be.
the difference? So.
Yes, it shouldn't be. I mean, you think about the amazing diversity among the states and diversity of diversity. I mean, the demographic makeup of the upper Midwest. Look at say where I'm going in a couple of months, South Dakota. I mean, their demographics are very, very different than what you've got here on some things, but on other things there are a lot of similarities. I mean, people with disabilities live essentially with the same ratio of population everywhere. I mean, there's some differences, but for other protected classes, there are big differences. And then there's also big differences in the extent to which the state agencies can bring different resources to bear. I mean, in Texas, you guys are really just about uniquely blessed in having all of your resources in one agency. Vermont, believe it or not, in Vermont, there are 4 agencies that do what TDHCA does. Maybe it's just 3, but I think it's 4 agencies in Vermont, which probably fits in the county that we're in right now. I mean, that's just crazy. And so Michigan's similar to Texas in that regard, so you're not totally alone. But it's really great that you can have a Brooke Boston that can look at all the different programs and think about that, as opposed to having 4 of them that each have their own little fiefdom. So, so that helps to a certain extent. You can bring all those to bear.
Thank you.
Sure.
Thank you, Mark. And so Scott, let's talk about the ICP too. You can either sit here or go up there, whatever you want to do. But Mark mentioned ICP. It's been remanded back, and kind of where we are with that. And then also, how have any of these decisions, whether it's affirmative furthering or the SCOTUS decision, impacted the way we've been doing business this last year, especially in local communities? So.
I think I will stand up.
Okay.
Had some great Mexican food.
Would you like to walk around?
I graduated from law school in '94 and really wanted to be a civil rights lawyer. I started out my career with this just real passion for civil rights, and went to Washington, D.C. and worked for a civil rights law firm there, and I was rewarded. My idealism was rewarded by my first assignment was to go to Lake Tahoe and speak on fair housing in '94. And my boss was in the audience, and I had all these cases and all just a lot of technical information about the Fair Housing Act. And after my presentation, my boss came up to me and he said, "Hey, you didn't do that quite right. This is really not so technical, and it's certainly not an extreme piece of legislation. And when we talk about it, we need to keep in mind that this is basic morality we're talking about, and it's really common sense legislation. And anytime you present on the Fair Housing Act, make sure you do that." And I think, sorry, but I think someone should have given that line to the Texas Solicitor General before he went before the Supreme Court, because I'm going to talk about the ICP case and what happened in the Supreme Court, and hopefully you'll get a sense that ICP went in there about this is about basic morality, and this was a real watershed moment in our nation's history, and they got 5 members of the Supreme Court who agreed with that. And let's just go back and talk about the ICP case. So I believe the case was filed in 2008, so we're now in our 8th year of the litigation. And I think it was in 2012 or 2013 when the court found that there was disparate impact. And the district court, Judge Fitzwater, found that the disparate impact consisted of a racial imbalance of the sites in 5 counties in the DFW Metroplex, that more than 92% were located of the units were located in areas of minority concentration, that the approval rates were much greater if you went into a QCT or an area of minority concentration with a 9% application than the approval rates if you went into a high opportunity area or one of the wider suburbs of Dallas. So once Judge Fitzwater found that disparate impact, then there was a court order. And the court order, it's really important to realize that I'd say 90% of the court order, maybe more, came from the department. The Judge Fitzwater asked for the department's remedy for this disparate impact. And so TDHCA proposed a remedy, and for the most part, the judge just adopted TDHCA's proposed remedy with all of the provisions in the QAP that we now have on high opportunity areas and undesirable neighborhood characteristics and things of that nature. TDHCA appealed that decision to the Fifth Circuit, and the Fifth Circuit ruled for TDHCA and found really kind of on a technicality that the district court didn't shift the burdens properly, but there was it's a 3-judge panel in the Fifth Circuit. One of the judges, Judge Jones, wrote a dissent in which she said, no, it's a much broader problem, that there was never any policy that was identified, and you don't just look at the racial imbalance of the sites. You need to figure out what is the policy that leads to the disparate impact. And I like to use, for example, a fire department as an example in the employment cases. If a fire department says that any applicant to be a firefighter needs to be able to do 100 push-ups, and then all the firefighters are men, then the court could find that the 100 push-up requirement is the policy that has the disparate impact, and so that policy needs to be undone. And it's really, to me, that's basic sense and morality, basic common sense and morality. And so she pointed out, Judge Jones pointed out that there really was no policy identified. It was just the racial imbalance. It would be like saying the fire department's all men. You need to start with the policy. So THCA appealed that decision, even though it seemed like they won. Again, they won narrowly. They appealed that decision to the Supreme Court. And in the argument before the Supreme Court last summer, the Texas Solicitor General really just focused on kind of the very technical argument that the word effect doesn't show up in the Fair Housing Act, so how could it possibly cover effects but not intentional discrimination? Really just a very legalistic argument that was made. ICP came in and strong with this. This was a time of great social unrest in our country. There was just rank discrimination happening in the housing market, and Congress finally, after Martin Luther King was assassinated, Congress finally decided to do something about it. And that grand purpose of the Fair Housing Act was a really huge part of what ICP brought to the Supreme Court. Justice Kennedy wrote for the majority of the court and very much got that argument. It really resonated with him, but he, at first it seemed like a big victory for ICP because the court was saying what every court of appeals had said that looked at the question, that Fair Housing Act doesn't just cover intentional discrimination where someone uses a racial slur, for example, but it covers disparate impact where it's a discriminatory effect, policies having a discriminatory effect. So that seemed like a big win for ICP, but the court said more, and the court really agreed with Judge Jones in the Fifth Circuit that we're not just looking at racial imbalance of sites. We need to find a policy that led to that racial imbalance, and Judge Fitzwater had never done that, and so the court wanted the district court to try to figure out what is the policy, what's in the QAP that's causing this racial imbalance. The Supreme Court also distinguished the ICP case from what it called the heartland cases where a local government is excluding minorities through its zoning power, for example. And you might have, and it's a classic disparate impact case in, for example, the St. Louis area. There was a suburb of St. Louis called Blackjack, and in that area, the first affordable housing development was proposed that had ever been proposed, and the council members just all looked at each other and didn't say anything, and then voted no, right? And so that was a classic disparate impact case where you didn't have any racial slurs, you didn't have evidence of intentional discrimination, but the impact was so great that here we have a mostly white suburb right next to a majority-minority inner city. When an affordable housing development was proposed, the city council just said no, and that there was a disparate impact there. So the Supreme Court said this ICP case looks to be a novel use of the Fair Housing Act. We agree that disparate impact is covered by the Fair Housing Act, but we haven't seen any other cases like this ICP case where they're challenging a state QAP in this way, and so the court really made that distinction. So what's happened since Deborah, you asked me to talk about what's happened since the Supreme Court decision. The first is really positive, which is that the court's use of that heartland language and talking about these heartland cases, that's actually helped in the heartland. I mean, we have seen cases since the Supreme Court decision where developers are going into high opportunity areas, kind of similar to that Blackjack situation, and city council members are being pretty jerky, and we're seeing local governments do some really jerky things, and we can use this tool that the Supreme Court handed us, and Coates Rose and other law firms have used that. TDHCA has been very helpful in those situations, so that we're able to use that as leverage to get the city councils and local governments to do the right thing in those situations. So that's been great. it's unclear what the decision will mean in the actual ICP case because it's just being briefed now. It's just being argued. I didn't actually go to the oral argument. There was an oral argument a couple of months ago on it. The policy, let's talk about the policy that was identified. The court said, identify a policy that causes racial imbalance. ICP has targeted board discretion primarily as the policy. A little surprising. I mean, many of us thought that they would point to political support letters, that requirement in the QAP, local government support, local political subdivision funding. I imagine they didn't do that because the time period that they're looking at is, for example, 1994 to 2007, something like that. And those provisions weren't in the QAP in those early QAPs, so they really had to figure out what's something that was common through a common thread through all of those QAPs. And what they seized upon was that the board was exercising its discretion, for example, the forward commitments. That if you look at the forward commitments made by the board, which had nothing to do with scoring criteria, that caused a lot of the racial imbalance in the Dallas-Fort Worth Metroplex. And the TDHCA has argued that that is not the type of policy that the Supreme Court had in mind, and that did not cause the racial imbalance, the exercise of discretion. And so we'll just wait and see what Judge Fitzwater does. I do want to talk, though, a little about something the Supreme Court said about the remedy. And the court had a discussion about the remedies in disparate impact cases, which not many people have talked about, but it's really interesting because the court said, if you think about that firefighter situation, the 100 push-up requirement, that the remedies really need to be focused as much as possible on undoing the policy. One of the most important reasons we start with a policy is because if we find that caused the disparate impact, then the remedy is to undo that policy. So if you kind of take that logic and you think about it, I mean, all of those provisions in our QAP today, high opportunity, undesirable neighborhood characteristics, educational excellence, all of these I use the term social engineering. There's a lot of social engineering ideas in there. If the district court finds that there's a disparate impact, it'd be very interesting to see what the remedy is for that. If board discretion, for example, is the policy, then do we remove board discretion from the allocation process for tax credits? Would the court order look very different from the court order that we got before we had the Supreme Court's guidance on what remedies are allowed? And just in closing, I'd like to give a shout out to Gary Sweeney because I started by saying that that this is not extreme legislation. That it's really, in a lot of discussions I hear, it becomes this hyper technical thing that's a gotcha legislation. I really believe that it is common sense and it is about basic morality. And I've worked with Gary on a number of HUD approvals in site neighborhood standards, and he has that perspective on the Fair Housing Act and has really brought that kind of common sense and basic morality to the discussions that I've had with him. So I'm very much looking forward to his comments.
John, I need a clicker. You need a clicker?
Not anymore.
Okay. Oh, do you need one, Susanna? No, it's fine.
No.
Yes?
We're getting the clicker up.
Okay, we're gonna bring a clicker.
Sorry, you didn't have a clicker.
Thank you.
I did not do the
Thank
clicker.
you. So, Gary.
Go ahead.
Here, I did a clicker. I don't have to apologize for my PowerPoint because I don't know how to do PowerPoint. As Deborah pointed out, I think very tactfully, he's been around for a long time. Not since '68, but I did come around in '77, '78. Firmly furthering fair housing. That's kind of the subject of this, and they've given a good legal background. I'd like to kind of take y'all on a brief little excursion back in time a bit to get us to where we were in 1968 when the statute was passed. 1968, as has been mentioned, that was a time of turmoil, A lot of this problems the federal government is responsible for, to be quite honest. We built a segregated public housing and affordable housing system using taxpayers' dollars. Our FHA single-family program encouraged segregation, our own federal programs. In 1968, of course, there was a lot of social unrest. 1968, President Johnson commissioned what was called the Kerner Commission. This commission, he said, well, tell me what's causing all of this unrest. It was like one of those old duh moments. Why are people unhappy? Why are African Americans unhappy in the inner cities? Well, first off, they're living in poverty. They have no jobs. They're living in substandard, government-subsidized housing, and there's no hope. There's the moral imperative, I think Dr. King said. There was no hope. So the Kerner Commission concluded that this country is moving to a country of a black, white, separate, and unequal. And that was their commission. That was their comments. Now, the Johnson administration did nothing with the report in terms of implementation. It proposed a lot of things. It proposed, at that time, billions of dollars in terms of improving conditions within the inner cities. Billions. Now, you imagine what $1 billion was in 1968? Maybe $1 trillion now? Don't know. I'm not a math person. But it proposed that you make these neighborhoods better, which we've heard discussed in some of their remarks already, and you provide opportunity. You build smaller, more affordable, more integrated, more financially or income integrated communities and areas of opportunity. They didn't call them areas of opportunities, but basically out in the suburbs. This was 1968. 1968, and we're still facing these same problems. And when in 1968, the Kerner Commission's report was dismissed. A few months later, after it came out, Dr. King was assassinated, and thus the heavily debated Fair Housing Act was passed. As a statute, it's a very weak statute in terms of enforcement. Our office, which is the responsibility for the enforcement of the Fair Housing Act, is with HUD. I'm the person in these 5 states that's responsible for making decisions on it. But this statute was very weak in terms of enforcement. In 1988, there were some amendments that gave us more enforcement authority in terms of the federal courts, which we have exercised quite a bit since '88. But in 1968, there was a provision which has been alluded to already. It was a provision, it was basically a mandate to HUD first to assure that all of the programs that it funds, and that's your community development programs, the old urban renewal programs, our public housing programs, housing choice voucher programs, our home programs, anything that HUD funds, our disaster recovery money, I see Dorlisi is up there, everything that we fund, that those programs are administered in a manner that affirmatively furthers fair housing. That means if a community gets this money, that community should make sure that people can live within that community free of discrimination on the basis of race, color, religion, and national origin. At that time, sex was added in 1974, and then disability and familial status was added in 1988. But live in that community free of of discrimination. That was a mandate in '68. Nothing really happened until probably in terms of that mandate and HUD doing something to probably, I think, the early 90s, when we came up with a process referred to as the Analysis of Impediments of Fair Housing Choice, the AI. Some of y'all, most of these communities still have AIs. It was a process that I think the GAO commented after they did a audit that led to really the implementation of the regulation they're working under now. It was a process that was not highly regarded in communities by our recipients. Some did a very good job, some chose not to do it. It really came to light in some false claims litigation, most notably in Westchester, New York, where the county had an AI that they did not even take race as a consideration. And they'd been certifying for years that they were affirmatively furthering fair housing. How do you do that if you did find impediments based upon race? So Westchester no longer receives entitlement money, community development block grant money. They have an agreement that they're still, the department's still trying to get them to adhere to. But where we're at now, why all the focus? Since we had this AI from say 1990 until July of last year when the rule was published, why now? Why it's important? But first off, the AI was something that recipients did. State of Texas did one, Austin did one, all the entitlement communities did these AIs. Did not even have to send it to us. My office, I'm responsible for enforcement of the Fair Housing Act. The document was never required to be sent to us. We could ask to see it. You know, they would report, the communities would report, the states would report on what they're doing to address impediments that they identified. But in terms in terms of really taking it serious, some communities dismissed it. They may have done one over that whole 20-some-odd year period of time. Some are very diligent. I mean, I throw kudos out toward the state of Texas and some other communities in Texas and in my region, because some of them do a very good job of it. And some of them did a good job because it's the morally right thing to do, I think. You got some city councils that are state legislatures that are very involved in this process. But some do a very good job in terms of administering it and developing, others don't. But in terms of why now the discussion, well, let me show you something real quick. This is the affirmatively furthering rule. No, it's not. This is the rule, and these are the comments. Over 1,000 comments were received on the affirmatively furthering rule from, you know, persons like yourselves, from states, local, you know, advocacy groups. Why? Because they asked the same question. Well, now the big difference is that my office will review these. The Office of Fair Housing Opportunity. Will we either accept what's called the assessment of fair housing, or we're not going to accept it? If we fail to accept it and we can't work out some sort of a acceptable plan of the recipient, the department will do what they call disapprove the consolidated plan. And that's kind of the roadmap for receiving our money. And that, for some communities, may amount to maybe $300,000, or it could be as much as, I don't know, the state of Texas receives millions of dollars. So now there is a club. Now, we don't like using clubs in the federal government, and I'm on the video here, a club, but there is a club. Like one of my former assistants, Office of Fair Housing Opportunity is a very small part of HUD. I mean, like, you put us on the flow chart, and we're kind of like, you know, there's 500 of us, and then there's all these other folks. So we're a small part. And one of my former assistant secretaries says that that the Office of Fair Housing and Equal Opportunity carries a very small club that we wield wildly, which we do. We touch upon about everything. So anyway, so now what we're dealing with is the affirmatively furthering fair housing rule. There's a great website. Go to HUD.gov and just put in the search engine affirmatively furthering. You'll get to the net, you know, kind of connected to all the different information on it. But where we're at right now in terms of HUD and the implementation is that the first assessment, the fair housing, that's what's called assessment of fair housing. This is a tool that the CDBG tool for communities has been approved, so that's out. So the state tool is, I guess the comment period is up, and has it been approved yet? Not yet. But this is the thing that we got all the great minds of HUD and the great minds out there and the great minds everywhere. We got together exploring. Well, let's set up a series of questions that you, the community, can ask each other as to why, if we have a all-black neighborhood that's been this way for the last 100 years, why is it that way now? You know, and just a series of questions are going to be asked. We're going to provide, we have provided, it's a data set, mapping tools. We're trying to make this assessment of fair housing to be an instrument that can be done locally with local resources, with local time, with local expertise, to make it as simple as possible where a community, a recipient can engage in an interactive process to develop a good assessment and proposed remedies to make things better. Now, in terms of who's going to be required to do this, of course, the entitlement communities, these are the Community Development Block Grant. I normally use a lot of acronyms, but this is the money that the state gets in the cities. This is something that goes to doing certain things for you know, social service type of things. The state's got a number of different things that they do, but this is entitlement money. It also is going to be affected our public housing authorities. This is something that's new too, as well as our home recipients, is that you have a number of different folks that are doing these assessments of fair housing. Our multifamily side is not, you guys don't have to do it unless you're a housing authority. So, because we don't consider insurance as being federal financial assistance in terms of affirmatively furthering. But in terms of the assessment of fair housing, this tool is going to be done, what the rule is, I'm going to try to keep under my 10 minutes. Tell me, Deborah, if I get over it. And I think most of you guys are in the housing business. I know Jay and I have had discussions. Of course, Scott and I have had discussions. I guess most of you guys are building stuff. What's good about this process is that the affirmatively furthering process requires active engagement. They call it consultation. Consultation with you guys. Consultation, of course, what you think of fair housing problems and NAACP, other advocacy groups, but more importantly, consultation with the people that are in the business of providing housing, affordable housing. I mean, a community where you have an interest, like whether you're in the state of Texas, certainly you would want to, get in touch with Suzanne when they start their consultations, but the consultant find out, well, what are some of the problems that you're having? And like Jay says, man, I tell you what, sometimes I get up there and we put this sign up that we're proposing to build something, and man, I start getting hate mail and people shooting at me, not in my backyard type of things, or there's other communities where we're trying to rebuild public housing in some of our disaster-affected communities, and the same thing's true as that HUD sitting back and saying, you're not going to rebuild on that site because you got too much public housing in an area of minority concentration, low-income concentration. Find a site somewhere else. So they can get the consultation with you guys, first off, in the community, this active consultation, because we're going to be looking at this. As we're going to evaluate with these tools, or these assessment of fair housing, my office is going to be looking for two things. One is that, first off, are they doing something that in effect it's going to discriminate? Say, for instance, if the assessment identified something and said, well, we found that there's an absence of housing for this group, therefore we're not going to rent to anybody else of other groups. That's discrimination. That's in conflict with the law. So that's one thing. It's something that's conflict in law. And the other thing, did they follow the process? Did they engage in consultation? Did they have effective citizen participation? Now, once they got the tool, are they having the meetings out there to let people know that this is what we've got? Tell us what you think about it, and then justify these comments. So we're looking for two things. So in terms of this process, in my region, I've got two that are coming due in October, and it has been fun. One is New Orleans, and you think of a better place to have an assessment of fair housing in New Orleans. And the other one is Jonesboro, Arkansas. We got two, one little place and one place that is about as ethnically, socially, whatever diverse. But it's been exciting because there's been a lot of engagement. So those are the two we have. The process is beginning. I think Suzanne's going to talk about where Texas is. So, but if I can leave you with something, she's got to tap out. Oh, she's trying to get. She's tapping me over here. So my time must be up. But short of it, if you take anything from my presentation, is know that this is a process that's here now. And I'm excited about it. There's not a lot of things I've been excited about in the last 20 or so years in fair housing, but I'm excited about this because this is something that can affect the quality of life for not just poor people that are living in areas of despair, but also to affect a community. Because people should have opportunity to if they're living out in the suburbs because the schools and the streets and the neighborhoods are inferior. Well, fix those neighborhoods. You should have done that in the first place. But you fix it, you fix the schools, you fix the transportation system, people will move back from the suburbs into your inner cities. And you provide the opportunity and the infrastructure out there for poor people that choose to go out where the jobs are, for them to be able to live there. So this is an exciting time for you guys out in the audience as well as us, the planners and the enforcers. So thank you all very much.
Gary, can I ask a quick question? It's a hard question, I know. But in the affirmatively furthering rule, HUD talked about using the assessment of fair housing in your other planning documents. And I think there's a lot of confusion about that because I'll just use Chicago as an example. Let's say that your assessment of fair housing in Chicago says that the areas of minority concentration are on the south side and on the west side of Chicago. The north side is mostly white. East side has a lake. Then you take that assessment of fair housing and bring it into your other planning documents. But what does that really mean? Does that mean that you have to spend 50% of your HUD funds on the south side and west side of Chicago, but no more than 50% on the north side? Can you spend 100% on the south side and west side of Chicago? I mean, how do you do that? How do you bring the assessment of fair housing into your other planning documents and consider it?
Well, that's a good question, because this is something, there's a couple of exercises that in my region we're going through. One is in Dallas. We have Dallas under what's called a voluntary compliance agreement, and they agreed to do a number of things. I think as they went into this VCA compliance, they contracted out, consulted out certain things in terms of just identifying issues within the city that they had. And Dallas was told basically, and I was at the city council meeting when they were told this, is that, look, it says your city is gradually dying, per se. And see, well, Dallas dying? It's kind of like telling you Austin's dying. It doesn't seem that way, but you're gradually dying because you have no middle class. Economically, the tax burden is upon the rich, the people in the North Dallas area. So you got to find something to do to bring the middle class, upper middle class, back to the city, to purchase, to buy, to live. So that kind of works into their transportation planning. The school district has hopped into this thing also. So you got a non-HUD entity that's involved. The Dallas Independent School District says, look, the studies have shown that the most economically, racially diverse schools are the most successful schools. If you make this diversity, but you can't just have one. So in terms of our money, of course, statutorily is good. HUD's money is going to be statutorily limited to low mod areas. We're not going to be building a lot of stuff out somewhere else. But the cities are going to be obligated to address these impediments of fair housing. So they're going to look at where this money is. Because, our money's not, you compare what Austin gets compared from HUD and what they get from HHS and other federal entities, they're going to have to I think, integrate this whole thing, the assessment of fair housing into all these. They're definitely, you're going to have to start thinking outside the box. And that. I don't know if I've answered your question or not. And that includes you guys too, because you're building the housing out there.
Thank you, Gary.
Okay, good afternoon.
Yeah.
So I'm going to be talking this afternoon about some of the department's efforts to comply with the new Affirmatively Furthering Fair Housing Rule. This went into effect last summer, August 17th, 2015. As Gary said, we've been under this for about a year now. The Assessment of Fair Housing tool replaces the analysis of impediments, the AI. It uses HUD-generated data. You can also supply local data if that's available, comprehensive policy, regulatory research, and a significant community participation process, as Gary mentioned. So the state will be identifying 4 main areas. RECAPS, which is a handy new acronym. I know we're all looking for more of those. It's racially and ethnically concentrated areas of poverty across the state. Patterns of integration and segregation, so the dissimilarity index that Mark mentioned. Disparities in access to opportunity, and disproportionate housing needs. So I wanted to share with you some of the comments that the department provided to HUD when we were looking at the release of the state assessment of fair housing tool. This has not been finalized. So the summary of the comments from the state include that this affects housing tax credits, and it affects the state's qualified allocation plan, as well as other state-administered programs related to housing and urban development. So it's pretty vast. These sources are outside HUD's statutory authority given to it by Congress. The state does not agree that accepting HUD funds requires the state to use its non-HUD funds in a manner prescribed by HUD. State, local, and housing authorities, there's actually 3 tools required by the new rule, will possibly produce inconsistent results. So if a local jurisdiction produces results indicating some disparities, and then at the state level those disparities don't show up, there are concerns about inconsistency. Ultimately, at the state level, those inconsistencies are watered down. There's a general concern that HUD will be in the position of determining whose assessment of fair housing is more right for different jurisdictions across the state. The tool requires the state to identify and prioritize factors that limit or deny fair housing choice or access to opportunity or negatively impact fair housing or civil rights compliance. The assessment of fair housing should focus on factors that are within the state's purview and for which the state can pursue achievable goals. Zoning and land use are determined at the local level and outside the state's control. There are certainly deep, long-standing, and broadly rooted causal factors for the conditions that allow the concentrations to persist. Many of these factors extend beyond the authority of the state. The Assessment of Fair Housing tool uses the clause "in the state," implying that even local demographic trends, laws, policies, or practices would need to be contemplated as in the state, not of the state. Finally, the department suggested HUD adapt clear definitions of areas of opportunity and areas of concerted revitalization and require HUD funding recipients to dedicate a specific percentage of their HUD resources to addressing those two categories. So that was kind of getting at your last question of if there's guidance for specific areas of concerted revitalization or high opportunity. So the National Council of State Housing Agencies shared similar concerns with the department. I wanted to provide a couple of those today. HUD estimates the assessment of fair housing for states will take on average 1,500 hours to complete every 5 years. TDHCA believes that number could be 4 to 5 times that. And again, this will happen every 5 years. Small and large states express concerns about the burden of complying with this rule without additional resources from HUD. Affecting change may require modifications to local policies that are beyond the state's legal authority. The state program participants are typically housing and community development entities lacking expertise in policy issues related to education, labor markets, public health, public safety, emergency management, preparedness, as required by the tool. So, for example, in Texas, the state will be required to address the statewide transportation network and education systems. Those are pretty hefty questions that the state will be answering, as well as local public housing authorities. So I wanted to share with you a draft timeline of the citizen/community participation plan. As you can see at the bottom bolded, Texas's plan will be due May 7th, 2019. This is a draft. There are a lot of moving pieces. This assumes no legislative changes, and the state tool hasn't been finalized yet. So this timeline assumes that that is finalized very soon, and we don't know that will happen. So the community participation plan will begin to be drafted in January 2017. That will be finalized by November 2017. Then we've allowed ourselves a year and a half to work on the state assessment of fair housing. And one important component of that, which is mandated by HUD, is that you hold a hearing at the beginning of the process to get feedback from stakeholders in the community, all sorts of folks on this. Then we'll be consulting with statewide groups representing protected classes. So again, that's race, color, religion, national origin, sex, disability, and familial status. So any organizations that represent those groups statewide will be consulted as a part of this. We'll be publishing a draft around December 2018. This will roll into the department's consolidated plan process. Final version of the assessment of fair housing should go to the board in spring 2019 and then be submitted to HUD. So hopefully this timeline provides some clarification for y'all as we move forward. We anticipate some changes if tools are not released pretty soon.
Suzanne, just a quick question. What does that citizen community participation look like in the eyes of the state?
So it's going to be a pretty long plan. It will also require collaboration across state agencies. Most of you know that TDHCA isn't the only department that receives HUD funds, so we'll be working with GLO, and we'll be working with some of the other state agencies to collaborate. We'll be doing an analysis of folks with limited English proficiency, figuring out which languages we need to address as we do marketing and outreach materials and how we're going to share the plan. HUD mandates that we share data. Most of that will be available through HUD's website. There's a lot of information that we'll be sharing to have a really robust process. So that document will be drafted beginning in January, working with the other state agencies. So I want to share, did you have a question?
I'm sorry.
Okay. So I want to share some of the department's current efforts to affirmatively further fair housing. Some of you may have participated in our spring webinar series. We celebrated Fair Housing Month with 3 webinars in collaboration with the Texas Workforce Commission. So the webinars covered fair housing overview, kind of a 101, reasonable accommodations, which is a very dense and tricky topic, and then tenant selection criteria, waitlist management, and affirmative marketing. Those presentations are available on our website 24/7. They're also accessible with transcripts, so you're welcome to watch those or use those for staff training if that's helpful. We also have the multifamily affirmative marketing tool, which is probably familiar to those of you in the room. So this helps our multifamily properties comply with affirmative marketing requirements. You just submit your property name and if it's an existing development with 40 or more units. The table on the right shows who you're required to affirmatively market to. Persons with disabilities always appear. For this property, they would also be affirmatively marketing to African Americans, Hispanics, and Asian populations. If a group doesn't populate, it's not considered least likely to apply. And this tool doesn't consider population results below 1%, and it doesn't consider multiracial household members in the data set. But this is available on our website and is used by all multifamily properties that receive funds from the department. Lastly, I wanted to share with you the department's fair housing report. So we track all of our fair housing steps. These are action steps to reduce barriers to fair housing choice. They can be associated with one or more impediments to fair housing choice identified in the 2013 analysis of impediments. It includes all fair housing steps the department takes, so for HUD and non-HUD funded activities, all in one report. It does not track efforts of other state agencies. They track those independently. An annual report went to the board on March 31st, 2016. A periodic update is actually going this week on July 28th, and it's in the board book now. It includes 184 action steps that the department has planned, implemented, or completed.
Thank you. Thank you, Suzanne. And we're almost out of time, but we will take a couple of questions. I know you had one, and then in the back. And then I'm sure our panelists will stay after to answer any questions.
I need to give you a little bit of, is this on? Need to give you a little bit of background. I'm a former mayor. I was mayor of Orange, Texas for 12 years, and so I understand disaster money, and I understand the rule. I've been out of office for 4 years. I embraced affordable housing. I embraced the new housing and putting housing in areas that had never had housing with equal opportunity before. But since then, and I became such a believer in this, I've gone to work for a development company that I had got to know when I was mayor. And, you know, this past year, I made my first, was going to do my first deals. And went to a city, and I'm absolutely convinced. The mayor there got me on the agenda. He was a lame duck, and he got me on the agenda. He believed in what we were doing, but I am absolutely convinced that the city attorney had advised that council to not make a motion. This way they would not be on record for either supporting or not supporting. And, you know, just the body language and my experience in municipal government, I knew exactly what had happened. So my suggestion to you all to the state and then also to HUD is that the Texas cities have a very effective trade organization, the Texas Municipal League. And my suggestion would be, and I also know under that umbrella is a city attorney's group. But this information needs to go before them, and their annual conference comes up in October. They need to hear this, and this way they can give their council some backbone. If the law is the law, these attorneys need to be told, you know, that they don't need to be giving their councils tools to circumvent the law. And I mean, I saw it firsthand. And I'm going to be back to see these same people again this year. But I really believe that the most effective group that this program that you all gave us today about affirmatively promoting fair housing should be at the Texas Municipal League Conference this fall. And also they need to understand what are the consequences, you know, and most cities, well, nearly everyone gets community development block grant funds. And I'm familiar with the plans, and everyone has to pass the fair housing resolution once a year as part of receiving federal funds. But they need a little reminder that that's just not a rote exercise that they do. And my specific question is, could a city, by approving a tax credit development in a very desirable area, and I'm using the word desirable area in town, could that be used as evidence of not having an impediment to fair housing?
Definitely.
And actually,
Cities need to be told that.
right.
That this will help you in your case of not providing impediments.
Well, Mayor, you're absolutely right. And this morning, there was a representative from TML here, and we said the exact same thing. The more education that we can give to your 1,200 members of TML, the better. I know, but not you, but the representative. And so we did. And they are going to have a panel, but we have to continue those discussions because I wanted to challenge Scott when he said, you know, it's really helped us get through some of these zoning cases, because I can tell you, Gary pointed out, Jay, we had an issue in Dalworthington. We've heard of issues, you know, in Bear County. I mean, there's issues still around the state where I haven't gotten the sense that it really has made a difference with local government. So I kind of wanted to know which ones worked for you. So.
Well, we've had some wins and we've had some losses. I mean, it hasn't worked. It hasn't uniformly worked when we've tried to use the tool. It's good to have the tool in the toolbox, but it's not going to work every single time. It's been helpful though, you know, one thing that you mentioned that I want to just point out to everyone in the audience is you talked about that the city acted differently on your affordable housing development than on other developments. They didn't make a motion, you know. And you can go back to cases in the 70s in fair housing. That's evidence of intentional discrimination, right? So that's the courts have identified that as evidence that what was really on their minds was who was going to live in the housing, and that's why they were acting differently. So I just want to point that out, that, you know, look for those kinds of things when a city acts jerky, as I called it.
There was one question, and we'll take that last question and then to wrap it up.
I was just curious, those were some pretty strong comments from the department on the, when you opened up your presentation, the last presentation. And I was so HUD about the program, and I was just wondering if there was any response from HUD on those comments.
So those comments were submitted. I want to say most states commented. You can read all of them online, but HUD hasn't released the final tool, and so then they'll respond to the comments just generally.
Okay, so so when the tool comes out, then that would ideally.
Typically, like Gary held up the affirmatively furthering fair housing rule with all the comments. The first 200 pages are comments, and the last 75 is the rule.
So again, I want to thank our panelists. Lots of information, and the reason that it is so important, because it determines where affordable housing will be located. It's that simple. And so we really appreciate all of the presentations. And if you have any questions, please contact our panelists directly. All of them are here to help. And again, thank you.